My name is John McKenzie. I am the Legal Services Commissioner for New South Wales. I've held this appointment since March of last year, so a bit over 18 months. In that position, I'm in charge of an office which handles, at least at the first point of contact, all complaints against any practising lawyers, both solicitors and barristers, in New South Wales. I, through my staff, handle approximately 75 to 80% of those complaints to conclusion and refer the remainder of it both to either of the professional bodies, the Law Society, or to the Bar Association. So it's very much that is our primary role, but we also have a role and participate in ongoing education of members of the profession with the overall goal of trying to work towards the outcome of working to reduce the number of complaints that might be made. There is another side to that coin that I don't think has been yet addressed, and I'd like to look at that in the future, and that is looking at some ongoing better information to members of the public in relation to what they might reasonably expect from a lawyer or not to expect. Because one of the things I have discovered in oversighting these complaints over recent years is the fact that in a number of them anyway, there is a very serious misunderstanding of what the role of their lawyer or the opposing lawyer may in fact really be. So that's my current position. Prior to taking this appointment, I was a practising lawyer, a solicitor for 34 years, primarily in criminal defence work. I was an accredited specialist in criminal law for the previous 15 years. I also had done some work in generalist suburban practices, but however, the majority of my legal career up to that point was working as a criminal lawyer for the Aboriginal Legal Service at various places around New South Wales and the ACT. So that's my story.
Thank you. The legal profession, certainly in New South Wales, is undergoing some significant changes. Technology, business structures, clients' expectations. Where do you see regulation sitting in the context of all of these changes? Is it trailing behind? Is it adequate? Or are there things that need to be changed with the regulation to make them relevant to what's happening in the profession these days?
I think that the whole issue of the changes that are afoot affecting the legal profession and the practice of law are incredibly important for regulators and everyone else involved in the legal system to be very aware of. I certainly don't think that it would be wise for regulators to be trying to predict in any detail what final form some of these currents of change might end up in. I think that would be very foolish, given the rate of change, the rate of entrepreneurship, which is obviously involved and will only continue to increase at probably a greater rate. What I do think the role in relation to regulation needs to be is to be having an eye on the obvious trends that are now coming through and what they point to in the future, and trying as best as possible to provide a framework which will be flexible and adaptable enough to be able to cope with whatever detailed outcomes eventuate from the various sorts of new trends that are coming through. In that regard, when I think about this topic, and I'm grateful for the Law Society and this whole inquiry for probably turning my mind and the mind of many others involved in this whole area to this important question, I do have, whilst I think there are some things that probably need addressing in relation to the regulatory scheme at the moment as we go into the future, and I'll deal with that in a moment, I do, however, take comfort from the fact of looking in some detail at the uniform law, the legal profession uniform law as it is in operation in this state, this jurisdiction, and in Victoria, for being rather ahead of the game in relation to the former Legal Profession Act at least, and the various versions of that are in force in the other jurisdictions in Australia. I think that some of the elements of the uniform law augur well for being able to be adaptable to whatever the winds of change are going to bring. I particularly think it's a good idea and one of the strengths of the uniform law that it in a very non-discriminatory way caters for all sorts of different delivery platforms of legal services. I think that that's a very wise thing for the future. I also think it's a good strength of the Uniform Law in relation to the previous Legal Profession Act, that it has turned to a general direction of principles rather than trying to set out a detailed list of do's and don'ts. For instance, in that fairly controversial area of cost disclosure, I think it's impressive and probably going to be helpful as we go into the future that it has returned to really a more principle-based approach of putting the emphasis or onus on the law practice, and it is framed in that way. So we do have entity regulation here already in New South Wales, as opposed to our Canadian colleagues who we've just heard about from Fred. But also that the whole basis of the informed consent that lawyers need to be working towards for each one of their clients. And I think it's a rather a good and adaptable basis for what's ahead of the legal profession, because enshrined in that is a necessity for lawyers to give some real regard to the nature and character of each of their individual clients, whether it be a company, a corporation or individual person. And according to the sophistication or otherwise of that client, to take, as the law says, all reasonable steps to make sure that that client understands what's planned, to get the actual steps or the course that's going to be taken in the legal matter, and as in combination with that, the estimated costs for that particular course of action, and that there be informed consent agreement with both of those things. I think that actually gives a pretty good sort of a platform on which there can be, if you like, catering towards whatever of the new technologies do throw up for the legal profession, because I think it harks back to one of the real great strengths of the legal profession and the practice of law, and the distinguishing features of some of their really core duties and responsibilities. And I think particularly in that regard to the paramount duty to the court and to the administration of justice. And very importantly, when we talk about the winds of change coming into the technology and the legal profession, the fiduciary relationship between a lawyer and his or her client, I think they are really fundamental and important distinguishing features. And what that leads me to is this, is that if there needs to be some real work and concentration on how we change any of the regulation at the moment around our legal profession, I would be suggesting that the initial emphasis at least needs to go to a further examination of just exactly what is incorporated or meant by the term legal services. As our friend from Canada, I think, quite rightly pointed out, there's that really important distinction at law between providers of legal information as opposed to legal advice. I think that some of these new technologies are going to really push our, shall we say, they're going to push the envelope in relation to which side of that divide, if you like, does this particular application or service online come down on. So I think that there could very usefully be some better examination of that. When I look at the definition of legal services in the Uniform Law, I think it could be improved, I think, in that it becomes a little bit circular, and that really says, well, it's work done in the ordinary course of legal practice, but there is no definition of what legal practice involves. I think if we in the legal profession want to be keeping up to date with the winds of change coming, we need to give some very serious thought about a better examination in detail of exactly what do we mean by legal practice. Because one thing that is clear at the moment is that if a particular service is to be regarded and accepted as a legal service, then there needs to be a registered practicing lawyer somewhere behind the delivery of that service who can be held responsible for any shortcomings or negligence or indeed misdeeds done in it. So I think that's the area that I would particularly think there needs to be some real work on.
Is that the area that causes you most concern, or are there other areas of change or trends that are taking place that cause you concern as well?
Look, I think that's the main area because I don't think it would be wise for any regulation to get into the practice of trying to predict where we're going to end up. I think it needs to be incredibly flexible, so it needs to be based on principle. I see that as perhaps the greatest assistance to people like me who have the job of regulating whatever law is in place. If we can go back to core principles and duties and think it through from that, I think we're best placed. The one area that I think it becomes obvious to me where there might also be some real examination about the current rules and regulation of lawyers is specifically in relation to lawyers' understanding and capacities when it comes to the new technologies. We have continuing professional development rules as part of the regulation of lawyers. I think that's good. I think there needs to be some real examination in the near future about possibly making it a compulsory component of that annual training to start to, shall we say, mandate that all lawyers need to be at least learning about such things if they don't know about it and increasing their knowledge year by year. I think that really only makes sense to us as an ongoing into the future as a profession because it is going to be such an important aspect to the delivery of whatever legal services are adjudged to be, that I think that if we want to be able to say we have competent, expert, professional members of the legal profession, we need to be able to say there is ongoing training in keeping up to date with the new technologies as they affect their legal practice.
John, I have a question. You mentioned that the nature of complaints shows that there is a serious misunderstanding of the role of lawyers. What are you finding is a sort of broad theme that people are expecting from lawyers that they're just not getting, and what's the nature of that gap?
Look, I think it falls into two categories. First of all, one of the first category that comes to my mind in the nature of the complaints that are very quickly dismissed in my office is the complaint that the other party in a dispute or litigation, that the lawyer of the other party ran all over my own lawyer. Now, when it's sort of boiled down, it's like, it's not fair. Their lawyer was better than mine. Now, I think that there needs to be a better appreciation of the fact that this isn't an adversarial system. It's a far better system than pistols at dawn. And that's what I take people back to, and I'm trying to explain to them that on the other hand, though, the system only works properly if everyone who becomes involved in the system has access to proper expert and professional legal representation. And I take on board the comments from Fred from Canada that there are real problems about unmet legal needs in this jurisdiction, as indeed all other Australian jurisdictions, as evidenced by the very impressive inquiry conducted by the Law and Justice Foundation of New South Wales a few years ago. So, look, that's one area. I think the other area is that there is an expectation that lawyers, when asked to deal with a certain matter, will necessarily deal with all other aspects of it other than the legal ones. Now, I think part of that the responsibility for this needs to be a better, perhaps public information out there about what lawyers do and do very well and what we don't do. But I also think it falls upon the individual lawyer to have perhaps address their responsibilities to better communicate with their client. Because I think at the core of a lot of the misunderstanding, if I could put it that way, complaints, is the fact that there needs to be much better communication from the beginning and through the course of the matter between the lawyer and the client. And I see that One of the things that I'm convinced of really triggers a great number of otherwise unthought of complaints to my office is what I call the nasty surprise. And that is the final invoice of legal costs at the end of a matter that may be completely justified in the work done, but the client is not in any way prepared for the extent of it. That triggers sometimes a reconsideration of everything that's gone on through sometimes a lengthy matter. So I think communication is actually one of the big things.
In light of the changes that are occurring in the profession, have you been faced with a situation where you don't have an avenue to pursue a complaint because of a lack of regulation?
I'd have to say my experience over the 20-odd months is no. Not yet. I think it's coming though. So I don't want to jinx myself and say that no, not yet and not ever. I'm sure it will come, and that's why I think it's very wise for us to be looking out towards the future. I've got to say that in particular to any online services, no, not yet at all. But I think it's only a matter of time. And that's why I think it would be a good time now, because I think the work that I'm suggesting needs to be done about a better examination and agreement upon what constitutes legal practice is probably going to take some time, because it's going to mean a lot of different points of view are going to have to be canvassed and considered. But in the end, I think there needs to be a better certainty about what is and is not to be included in this thing called legal services, if we're going to have ongoing regulation of that and a requirement that it only be provided by lawyers. So, but I've got to say no, not at the moment. I've been waiting for them, and I'll keep my eye out for them, but not as yet.
So no one's complained about the will that they've bought at the newsagent or the shareholder agreement that they've bought from
No.
provider online?
No, not a single one of those instances. No.
Do regulators across jurisdictions talk about these issues? Is there a tendency towards a uniform approach, or are we all dealing with our own separate individual issues within each state and territory?
Look, I wouldn't like to say an either or there, Gary. There is differences of opinion. There's a very strong matters of history and pride in relation to each jurisdiction. I'm a great believer and advocate of the uniform law should be applied all over the Australian jurisdictions. A number of my colleagues from other jurisdictions disagree with me, and we have some very animated discussions. But that's only one part of the answer to your query. On the other side of the coin, yes, we do have a lot of commonality in the sorts of complaints that we deal with. And it's interesting when we get down to tin tax, and sometimes we see some important differences between, shall we say, the arsenal of powers at our disposal because of the different laws in place in some of the different jurisdictions. They're not great, but they are there, particularly in relation to matters such as the vehicles used for delivering legal services, so alternative business structures, as I think is the term. Some of those other jurisdictions really find themselves quite powerless to be able to do terribly much in relation to the entity as opposed to the individual lawyers. I think that they see the shortcomings in that. I think that in relation to other matters, I think that we are very much talking about what we see coming on the horizon. All that I can say is that I think the whole administration of it, let me put it this way, given the irrelevance of state and territory borders when one is on the internet, it only makes more sense to me that there be an irrelevance of state and territory borders when it comes to the regulation of the legal profession. As I say, some of my dear and fondly met colleagues disagree with me on that, but that's my view.
Are governments engaged in this discussion, or do they rely on the profession and the regulators to raise these issues?
I think they rely on the regulators and the profession to raise these issues. Oh, I have to be careful. I think that governments have so much on their plates these days that this is a bit of a low order of things, quite frankly. It's not until there's something really, shall we say, hits the pressure points of media coverage that they will have any interest in this at all.
Understand.
There's been a really significant increase in the number of lawyers coming into the market in New South Wales, at least. Has that reflected in an increase in work for your office, or are there any trends that you see that are related to this increase in the number of practitioners out there?
I'm very pleased to be able to say no great increase at all. When I look at the burgeoning number of practising lawyers in the state, I'm looking, that is, we're now approximately 33,500 practising lawyers in New South Wales. The number of actual written complaints received by my office has been approximately static for the last 7 years. So I think that speaks very well of the fact that it is not causing an increase in complaints. However, I'm always mindful not to be complacent in any way. One of the areas, though, that the large and increasing number of young entrants into our profession is causing me concern is that I am worried about the nature and the standard and the competence, if you like, of the supervision being given to them in their 2 years of initial practice. I think it's a very wise thing that our profession has that mandatory supervision period. I am concerned that there are some instances where the young entrants are not being given a professional supervision that I think they are entitled to expect when they join our profession, and which the clients are entitled to expect is going to be practised when they are placed in their legal matter, which may be rather small to other people, but it is incredibly high stakes to them, is placed in the hands of a new entrant. So I am very alert to the fact that I would like to see a better appreciation and assuming of the responsibility for proper supervision by the more experienced and senior members of our profession to those entrants.